All right, it is 6:30. I'm just going to give another minute or two for people that might be signing on late. So those that have already signed on, if you want to grab some coffee real quick, give it a minute or two, and then we'll jump right into it. Also, for those that are listening, if you want to just note in the chat panel or the questions real quick, just to confirm you can hear me so that I know when I start that I'm broadcasting. Appreciate it. All right, if anybody listening, before we jump into this, can just confirm you should have a chat panel on your right side that gives you either a pull down for questions or a pull down for chat. If anybody could just note in there that you can hear me, because I'm testing the audio and it says that it's reading me, but I never know. And every time I do this, I'm doing it from different locations. All right, I just sent a message out on the chat to the entire audience. So somebody respond so I know that we're broadcasting. I know everybody waits for everybody else to do it. All right, I'm going to jump into it. I'm going to hope that you can hear it. I'm hoping that somebody will point out if they can hear it as the slides start to move. So good evening and welcome to the Micklin Law Group's, I wanted to say monthly, but it's really bi-monthly webinar series. Tonight's webinar is the 7 shocking statistics about fathers' rights in New Jersey. I appreciate you waiting with me, and let's jump into it real quick. For those that don't know me, this is me. My name is Brad Micklin. I'm a New Jersey attorney. I'm the founder of the Micklin Law Group. We are a law firm concentrated in empowering men and fathers in divorce, custody, and family law matters, with offices in Nutley, Montclair, and Saddlebrook, New Jersey. Real quick, a little bit about how the webinar is supposed to go. It is scheduled for, it's scheduled for an hour. It doesn't usually take that long. It's usually about 30 to 40 minutes. I tend to talk faster than I should, so it doesn't take as long as it probably should. And I apologize if it's hard to keep up, but I'll do my best to speak slowly. As you can tell, it's a one-way communication, so you should be able to hear me. Hopefully you can hear me, and I can hear you. There is a chat panel, as I mentioned a moment ago. It should be on the right side of your screen. We'll have a pull down for chat and a pull down for questions. I would appreciate if you have questions, feel free to put them up there. I usually wait until the end of the webinar to address them so that doesn't break the flow up and I can make sure to get everybody's questions at one time. I will stay as long as necessary to answer your questions, so you don't need to worry about that. But I would recommend you write them down when you think of them as opposed to waiting till the end. That way it doesn't slip your mind. The PowerPoint that you're going to see tonight is also attached to the chat panel at the bottom, so you can download it. It will have some statutory citations that I'll refer to. It also has a site to the source of the facts and statistics that I'll be referring to tonight. So feel free to download that. It will also be uploaded to my YouTube page, usually within a week or two, and sometimes to my website, but I don't put everyone on my website. So it's usually better to go to the my YouTube page. I see some people saying, oh, that's what I want to say. Right. So the people that are in the attendees, my understanding is nobody can see anybody else, so that it protects your confidentiality, that nobody knows if you're attending. They shouldn't be seeing your names. They also don't see who you are when you post questions, so you don't have to worry about people having any kind of input into your situation or who you are. It does not show on the recording either, so when it goes into YouTube, there's nothing there about any of this part. I see some familiar names. I appreciate the support. Good to kind of see you guys again. Hope this helps, and if it doesn't, certainly message me later with what and how I can help you. So these are a handful of awards I've been privileged to receive over the last, 20-something years of practice. I don't put them here to impress people. I put them here to impress upon you that I've been doing this a long time. I feel confident in the work that I do. I care a great deal about it, and I hope that these awards just reflect that. I've also been fortunate to do some guest appearances, legal commentary, Fox News, Larry King, Inside Edition, CNN, and many others. Again, just to show what I hope it suggests, that I do know what I'm doing, and you can trust the information that you're getting from me, and you can feel confident to come to me for help or any questions that you may have. With that, let's move into father's rights and custody. All right, so fact number one, that the percentage of children in one-parent households living with just their fathers increased. In 2007, it was only 12.5%. In 2017, it's 16.1%. Whereas the vast majority through all those dates have lived with their mother, which is the historical fallback. And I want to point out at this point in the webinar too, some of the dates are going to be a little older. Two reasons. One, they don't compile statistics like this too often, and it takes 10 years or so to measure significant difference. But also the last year or two, I think most people will acknowledge with COVID that a lot of things have changed. A lot of these numbers have changed. Now, we don't know necessarily if it's permanently or not. So when you see like 2017, 18, it's because 19 and 20 were a little unique, and we don't really have all the information there just yet. So what those numbers I feel show is a growing trend towards equal parenting rights. It's also a trend of fathers seeking more time and not just being what I call weekend dad. The traditional parenting time for fathers had always been alternating weekends, maybe a dinner visit, some holidays, maybe a school break, and some summertime. And I think a lot of fathers were resigned to that being how it is, not asking for more, not even realizing that they could. And those, 10, 15 years ago that did try and fight for those rights were often denied, probably without any cause. And it discouraged, I feel, a lot of people following that. As I mentioned here, there's a lot of proposed legislation, some in New Jersey in the recent past, and obviously in many other states, to codify this trend and to create a presumption of equal rights. Now, New Jersey had a statute proposed not too long ago to make it a presumption that fathers got equal rights, equal time. And then from that point, it would be overcoming that presumption to change it. Unfortunately, it did not pass. There was not enough support. I am kind of shocked by that, giving what I believe to be the more liberal edge of New Jersey, that we didn't. And it's hard to understand how you can justify not supporting that a father has equal rights to equal time. So what we have now is maybe the next best thing, and it's a statute that says both parents should have as much time with their child or children as possible. Now, that doesn't often mean a great deal when both are working 9 to 5. You would think that would lead to a 50-50 sharing time, and in many cases it does, but it's still lacking in the absence of the equal rights presumption that we hope will return at some point in our near future and then become New Jersey law. Number 2, moving right along. Children between the ages of 0 and 5 living with one-parent households is 28.5 with their mothers, 23.9 with their fathers. Now, well, let me go through the stats. Between the ages of 6 and 11, we have 34.9 with the mother, 32.1 with just the father. And then from 12 to 17, we see a shift in these numbers to 36.6 with mom and 44 with dad. I have to take 1 second and send a quick message out. Sorry for the delay. Actually, I'm gonna all right, so a couple things. First, when I first looked at the stat, I'm like, well, there's a third missing. The numbers don't add up. But then I realized what I feel the absence represents are children of these ages living with a third person, grandparent, a sibling, just a person who sought custody, because any person can seek the custody of anybody's child under New Jersey statutes, and that's where I feel the numbers are. But these numbers are very interesting. First, you see, well, let's go to the next slide, but I'll go back to this. So first, you see as the children get older, the proportion living with their father significantly increases, especially when you get into the teens. And I think that what I see a lot is because, quite honestly, teens are difficult. I think most parents would agree. Often there's, gender identification, boys want to more often live with their fathers. Girls sometimes have trouble with their mothers. Not to generalize here, but that's a lot of what I see. So as they get older, we do see a lot of shifting in where children are living. And that's also because, at these later ages, a child's desire becomes relevant. Now, it's not that they can decide. I've never seen a court let a child decide. I even had a case with a 17-year-old who was going to college. Judge wouldn't let her decide which parent she lived with because it's a difficult decision for any young child, and it's hard to trust the decision when they're put in between two of their parents. But as they get older, courts do consider it. So around 13-ish, the opinion of the child will matter. I also think, as I mentioned here, that I think part of this is suggesting that we're moving towards a more balanced, I don't want to say equal, but a balanced approach to parenting. And here I reference the 10 years doctrine, which basically says in New Jersey and many other states believe that a child is best suited by being with his or her mother when of tender years, like let's say 0 to 4. In most cases, that's really not the case, with the exception of maybe if a young child or an infant is being breastfed, but even there are ways around that. But I want to go back 1 second to the other one, because first of all, the last number that I talked about throughout most of this, the 12 to 17, is almost a shocking number. Not only is there a substantial increase from 0 to 5 to 12 to 17, but it's a greater percentage living with the father at that point in time compared to every other age group. And I think there's a lot there to be considered. But also, even when we go 0 to 5 and 6, we have nearly 1/3 of basically infants, preschool children, infants living with their fathers now. At 6, when we're largely in school or at school age, we have almost 1/3. And to those fathers that are fighting right now, it's a great sign. Those that have gone through it in the past can at least see that there is a significant trend towards recognizing fathers' equal rights. And I think these statistics, more than most things we'll talk about in this webinar, are showing us this. So let's look to the next fact, which has a little bit maybe of outdated information, like I was saying. So back in 2010, there was 13.7 million parents that had custody over a child whose other parent lived somewhere else, meaning one child. In 2010, only 1 in 6, or 17.8%, they estimate, was with their fathers. So this is even more telling when we look at the trend over a 10-year window, which isn't a great deal of time when you think about how the laws develop, because law is very slow to catch up. They do use, or they try to use, a lot of psychological texts and theories to support parenting. So the mindsets of psychologists, psychiatrists, medical professions need to change before it filters down to the courts. And I think generally lawyers are very slow to change at all. I still know lawyers that use pencil and paper to take notes. So it is catching up. But I think when you look to the fact that in 2010 it was 17%, and now in some of the numbers we looked at before, when you look at the age groups, you have between 30 and 44%. It's nearly triple in the last 10 years, and I just think that's astonishing. And hopefully parents that are fathers that are listening and share that sentiment. I want to give a quick check. I haven't had anybody respond. Okay, somebody did respond that they can hear. Good. Real quick check. Just could somebody post if you can hear me now still? I want to make sure that I don't hit anything and then change any settings and turn off my sound. So if somebody could take a second and put either into the questions or into the chat that I can be heard. I don't like to sit for too long waiting. But then I get where, okay, all right, good. So it looks like we're good to go. I probably should have put this slide up when I did that, because it's kind of like a break slide in case anybody needed to take a break. We're only like 15 minutes into this, and we're largely, half, if not more, than the way. So I don't think I'll need to stop the video here for breaks, but feel free to take a break. If anybody does need to go and you want to just pop up on the chat asking me to wait a minute, I wouldn't mind doing that. Obviously, I can't ask everybody to sit around for several minutes, but do what I can to accommodate. If you got, quick urgency, you might have your children there, you got to go run and get them, whatever. So turning on to number 4, of the 17.8 that I just mentioned, in 2010, 18.8 were living below poverty level. And there was a higher percentage of custodial mothers living below poverty, but they're less likely to be employed than the fathers and more likely to receive governmental assistance. So what these numbers, I think, suggest 2 things. First, that the fathers that are fortunate in obtaining custody seem to be in a greater percentage of low-income individuals, which could suggest that was why they were successful in the court. Either their partner, the mother, also was low income. There might not have been attorneys involved. But I think when we look at the additional statistics, that they're less likely to be employed, or the mothers are less likely to be employed, which would obviously be a significant cause of why mothers would be at poverty level. So it's saying that fathers that are employed are at poverty level, mothers that aren't employed are at poverty level. So the men that are working at minimal jobs, quite possibly because it's very difficult to keep a good job as a man who has custody, especially if they have primary custody or equal custody. But then when you look at, the mothers are more likely to receive public assistance, suggests a potential bias in the system. It could suggest maybe a mindset that fewer men seek welfare or public assistance. I'm hypothesizing. I don't have statistics on this. I'm not trying to suggest any inside information about who or why or what makes people seek public assistance. But I think the numbers are significant when you consider that custodial mothers at the poverty level don't seem to have as difficult of a time in supporting themselves and their children as fathers does, which would be another hurdle for men who are seeking custody, especially if you're lower or poverty level income. Number 5, intentional interference with custody or withholding of visitation without just cause could, 1, justify a change in custody, some adverse consequence or punishment, sanction from the court, or criminal penalties, fines, and imprisonment. Now, this is true as it exists on the books. It's a crime of the second degree if you take, detain, or entice a child or conceal outside of the U.S. It says outside or for more than 24 hours, which means if it's in New Jersey or the U.S. overnight, it can be interference with custody. And it's a crime of the third degree, a presumption against imprisonment. Now, this sounds good. So actually, before I get into the reality of this, a lot of people confuse this with kidnapping. And my understanding of how the criminal code works, or at least the belief and intention behind it, is that you cannot kidnap your own child. And I think for some time, I don't know if the law actually recognized that, so they did allow natural parents to be charged with kidnapping. I believe now that that's not feasible and that it is instead an interference with custody. The problem is that it's rarely used. First, as I mentioned in the PowerPoint here, police don't like to get involved. They'll tell you it's a family court matter and you got to go to family court. And, I have a personal issue sometimes with how police handle a lot of family law issues. No offense to them. I know they're doing a great job. They put their lives on the line. And the last thing that they want to do is get involved in a custody battle, which quite often is a family law matter. But there are times where their assistance is needed, like domestic violence cases, it's often problematic. And in custody cases, they have limited authority, of course, but I think they should try to use it as well as possible. And then lastly here, by the time it gets to a judge, so much time has passed that the urgency has dissipated, has passed. Let's say you have a custody agreement. You're supposed to get your son back at 6:30 Friday, and they don't bring him back at all until like the next week. They just kept the child, won't tell you where they go. They go on vacation. They don't give you an itinerary. They go on a trip and they don't tell you where they are. Countless possible scenarios here. So your options would be an order to show cause. People that have been through the system know it's an emergent application asking for immediate assistance, which usually in a case like this you would get if you say, hey, my child is missing. I can't find the child. The courts will likely enter an urgent order for some kind of relief, like having mom have to answer or the other parent have to answer, or scheduling a hearing more promptly than they would if you filed a motion. And the other choice is to follow a motion. But either one will take about a month or two to resolve. Even the emergent order to show cause might give you an expedited return date, but that date's just going to be kind of like a starting point. It's a fast starting point, but it's a starting point. And then a month or two later, judge is going to look at what's the harm. The children back. You get a slap on the wrist, like a don't do it again. So I mentioned in the earlier slide that there's adverse consequences, sanctions, and a lot of other relief that a court can enter when there has been interference. And I don't necessarily mean just what meets that statute, the custodial interference or 24 hours, but kind of any interference, and this may come up later in another slide, but like if somebody routinely interferes with parenting time, it may not be 24 hours, it may not be out of the states, but somebody's constantly late, somebody's constantly changing parenting time, somebody's constantly withholding parenting time or frustrating parenting time or alienating. These are all examples of issues that the courts will intervene and take adverse action or impose consequences, not just custodial interference. So some of the things that I find courts commonly do, they will order Our Family Wizard, which is a program that allows you to communicate with the other parent on an online website. And what it does is it tracks communications. It allows you to pass messages back and forth and receipts, but it also allows you to document the time of messages, how long, if at all, responses are received. You can print them out in an orderly fashion and present to the court. So it kind of organizes the conversation for proof purposes, really. And it's more often than not used in high conflict or troubled custody arrangements. Several types of counseling: therapeutic, alienation, which is sometimes called reunification, custody evaluations, risk assessment, psychological evaluations. I didn't skip over anger management in case you're following along with the slides, but that's not really a counseling as much as it's a program. Very common, especially when there's parenting issues involved with a restraining order. Same with the risk assessment down below. And then how it impacts custody and parenting time is that there can be a modification, there can be a suspension for the parent who is frustrating it. They can be supervised if there's a suggestion that one of the parents is a potential risk of harm. And then there's sanctions and counsel fees. Sanctions I don't see too often in a custody dispute or an interference issue. Counsel fees more often than sanctions. Sanctions can be like a daily fine until like a child's returned, or daily fine until there's compliance with something or something is paid. But counsel fees are more common than sanctions, but counsel fees are not very common either. Even when there's contempt of a court order or clear parental interference, I tell all my clients, don't anticipate or plan to get your fees back. If you do, you're ahead of the game. And if you don't, you're exactly where you plan to be. So don't go in thinking that the money's coming back to you. And, I probably mentioned in my other webinars my theory about that, but I'm not going to take the time now because I want to move forward through some more of these fascinating facts. Number 7 is, according to the U.S. Census, that nearly half of the fathers that don't have visitation rights still support their children. Now, I don't know if that means because they're court ordered or because they're doing so voluntarily. It's probably a combination of that, and we'll get into a little bit about parenting rights and parenting obligations. But I think it speaks volumes, because even if you're court ordered to pay support, we all know that there's ways not to do so. The term deadbeat dad, which is also offensive when you think about it, because there's not a term of deadbeat mom. And I know many mothers who I've had in my cases, not my clients, but my adversaries, who are not very good mothers, that are not seeking custody. It's a trend that I see more and more often. Not to disparage women, of course. I'm not making any generalized sweeping statements. I'm just reporting what I've seen. And there are, I don't know if I could say as many, but there are enough of women who aren't supporting their children, who aren't seeking custody, who pose a risk to their children or interfere with parenting time. So the fact that nearly half of men without visitation rights are supporting him. And lastly, on this point, we're not saying that they're not choosing to see them. They're saying without visitation rights, meaning a court didn't order that, because you would, the only way to have a visitation right is to have it ordered. And it just was an interesting fact to me. I think it says a lot when we hear things like deadbeat dads, that parents, that fathers that can't see their children still support them. Now, into that, so in 2014, this kind of relates to the last fact, but shade gray, there were 7,282 parents who weren't receiving child support. Only 1,100 of these were mothers. And they said they didn't want their children to have contact, which suggests that they forgoed, not even sure which one I used for that, seeking child support to enable them to have less parenting time with dad. Now, technically in New Jersey, you can't waive child support for a child because it's the child's right. But if the mother doesn't seek it and there's no issue in court, it works. If you carefully draft the agreement with certain language, it can be accomplished. These numbers, almost a third didn't want contact. And it's problematic not just from the fact that they refuse support, but there's that many parents who are trying not to have the father have contact with their children. And I go through this all the time with my clients when we go and petition for custody, and that all of a sudden mom says dad needs a risk assessment, dad needs a drug test, dad's not capable of having overnights. And it's frustrating because more often than not, these families have several children. So they've co-parented several children for many years, and all of a sudden, now that they're getting divorced or they're living separate or there's a new girlfriend in the picture, now all of a sudden they can't and aren't safe around their children. And it's a compelling argument because courts are always concerned with protecting children. So when you go into court and you certify under oath that there's a risk, drug use, an anger problem, an abuse issue, they will often overreact to make sure the children are protected, but that ends up impacting the father's rights and for a very long time. And it's not right. And it's unfortunate that it's hard to monitor who's telling the truth and who's not, and that more, and on top of it, there aren't a lot of sanctions for the people who are making up these stories, who are frustrating, for the 1,128 women who said they don't want parenting time. There's very little repercussion for that. So going back to the beginning of that, where I said that rights, I mentioned rights and responsibilities. Judges are making clear parenting time and child support are unrelated. So you can be ordered to pay child support and denied any right to see your child in New Jersey, which is appalling. Now, the reason for that, as far as I understand, is really a financial issue with the courts, with the state. New Jersey does not want to have to pay to support anybody, especially another child. So they want to make sure that the parents support the children. Whether or not they see them isn't really their concern. And if they're not allowed to see them, it's even less of their concern. They want their child support, and they want to make sure that they don't have to go on welfare, which is also why it's very easy to have it paid through the court, the probation department, wage execution, and the enforcement is much more rigorous than it would be on your own. You can't utilize self-help by holding parenting time if there's support arrears. Now that inures to father's benefit. So conversely, if you're not that I'm encouraging, but if you're not paying your support, mom still has to give you the child if you have court-ordered parenting time. So at least it's nice to know there's a balancing of the scales to that extent. And lastly, child support, as I was saying, the reason they are so rigorous to enforce child support is because they want to make sure that the state doesn't have to support the child. They can suspend your driver's license. They can actually suspend a professional license, a passport, arrest warrants. It's a very rigorous enforcement mechanism. And it doesn't cost the other parent a dime when the court does that. And I'm not saying that that's a bad thing necessarily. I mean, I think people should be supporting their children. It just concerns me that there can be such severe consequences for not paying child support, less so compared to a parent who uses self-help and denies parenting time. So while they're not intertwined, they should be at least of equal standing. And right now they're not. And a bonus fact. Yes, I said 7, but we included 8. Simply just because the information that I was reviewing had more than I thought I was going to cover in the beginning. So in 2012, 28.8 of fathers received child support either through an agreement or award, compared to 53% of custodial mothers who did. And again, what we keep seeing through all of these is a disparity, a significant disparity between either the rights or the receipts by a mother as opposed to a father. And I think that, it suggests a lingering stigma against men having custody and about getting support. As an attorney concentrated in men's and fathers' rights, I still hear a lot of men who come to me and say things like, oh, I don't want alimony, when the numbers clearly suggest that they should receive it, that the law would support them receiving it. They don't want it. Same with child support. A lot of men will say, I just want my child. I don't want support from mom. I don't want anything. And I get it, and it's obviously your choice, but I think that it's a little short-sighted. I usually suggest clients reconsider that because, first, more money is better for children. I don't care how much money you have. The more, the better. And if you don't need the money or you don't want to use it out of principle, put it in a college account, put it in a trust fund, put it in a savings account, and just bank it there and leave it until the child's older and, give it to them when they're responsible enough. Buy them a car, use it for college, whatever it could be. You never know what's going to happen in the future. So take it while you can get it. And the last point is judges may be less inclined to award support to a father. And I don't mean just alimony. I mean child support. I had one case, and it was a lesson learned because there's very few times I've ever said to a client, yeah, I'm certain that you're going to get this, or you're guaranteed to have this come out, because nothing is certain or guaranteed. But I thought getting child support for your children was, given what I keep saying through this about the strong public policy about collecting support. So I had a client, his name was Chris. He was the custodial parent to his child. His income was like a little over 100,000, but this was a few years ago, maybe even like 5 or 8 years ago. And it was over 100,000. So he made a comfortable living. And his wife was pregnant with another man's child, his ex-wife, let me say, which, as a side, we divorced them at like 8:00 one day. And then she brought her new husband to the same judge that afternoon for them to be married. So this is who we're talking about. So ex-wife, mom, is on welfare because she's pregnant with this other man's child. So I say to my client, well, just and the only reason he wanted support was because she kept filing to get custody back. Sorry for the war story, but we're closing out here. So he said, I'm just filing because she keeps filing for custody. I have to keep taking off work, spending legal fees for this bogus claim because she's not qualified for custody and the court doesn't sanction her. So if I go for custody or if I go for child support, at least it'll keep her from coming back to court because she'll have arrears and she won't want to face it. So I said, all right, ask for a nominal amount. They have to impute income because she's willfully underemployed. She elected to get pregnant with another man's child. She's getting welfare. He's working, the new husband. You should at least get a nominal child support award, $50, and just let it accrue. And the judge actually denied him child support, saying that it wasn't, that the mother shouldn't have to suffer to provide child support because his income was sufficient, which is appalling because, as I said before, the more money, the better. And I guarantee you, if genders had been different and mom had custody and dad was remarried with a baby coming and he was on maternity leave, he'd still be ordered to pay child support and probably much more than a nominal amount. And it was really, really disappointing to hear this kind of decision. But it was also a lesson learned because I told him, yeah, you'll get child support because I never knew of any reason that you could deny somebody with custody a child support when the other parent is healthy and capable of working. But lesson learned nonetheless. So that is the conclusion. Those are my 8, despite the title, fascinating facts about men's and fathers' rights in New Jersey. So let me see if there's any questions before. Let me see. I got to expand the panel, I guess. That didn't work. I'll expand the questions. All right, so I don't see any questions. We still got a handful of people that are here. And a quick hello to some people signed on late that I didn't get to recognize. I don't recognize anybody by name, but I do recognize some people, and I just want to give you a quick hello. All right, so we have a question popped up. Any thoughts on the challenges out-of-state fathers might have? Do you mean the challenges a father has if he's living in a different state than the child and the mother? And are we talking about like a traditional parenting, like getting parenting rights or enforcing parenting rights? Maybe give me a little more of what you're concerned about. Well, I'll start talking while you're thinking about my question, see if there's any more specifics you give me. So that, by the way, I have several dogs here. One of them sitting next to me and just burped. And if you happen to hear it through the microphone, that was not me. Okay, so a little clarification on the question. Never married. Mom and child live in New Jersey. I live out of state. Fighting hard to get more time with child. Mom is trying to exclude me as possible. All right, so well, there's a lot of issues to living out of state. There's a lot of issues to any kind of distance between houses, but when you're out of state, it usually suggests many. So the challenge is, one, getting a schedule that works, because, and depending on the age of this child too, because if you're going to be spending 30 minutes in a car, an hour in a car, the argument's going to be, well, you don't have quality time. So a dinner visit, for instance, on a Wednesday is out of the question, unless you want to drive up and you do an hour of driving to have an hour of time, 4 hours away. Okay, great. So the question is, what are the challenges? And I think the post here is what can he do or argue? Then he's trying to get parenting time. He has a 3-year-old that lives 4 hours away. So that's a very challenging situation because you have a lot of time in the car. Now, first, you open up by arguing that that's quality time. 4 hours in a car. I mean, even though the 3-year-old might become crazy, it's still 4 hours where it's one-on-one and there's no interruptions, and you can, depending on like what media you have in a car, but it's quality time. But don't look at a traditional schedule. And I say this to a lot of parents, don't just think you're bound by what everybody else does. So what I think you want to do, since the child's not in school, it's really a question of how do you maximize your time and minimize the inconvenience to the child as well as the mother, because that's always a compelling argument. You want to look for larger groups of time, like, there's a lot of holidays where you have extended time off, the Monday holidays like Martin Luther King and President's Day. You might want to build in that you get, instead of having every other weekend and driving 8 hours, maybe you have one weekend a month, but or that one weekend will always be on the Monday holidays, which, or on a holiday, because I think almost every month has some holiday somewhere. So you get extended parenting time where you can really enjoy the time. You want to ask, when the child's school age, for a greater share of the extended school vacations. You got winter break and summer break and spring break. Get those by giving up the frequency. So instead of saying, I want to see him every weekend for 2 days, I want to see him every month for 4 days. I want to see him for 3 of the 4 school vacations. I want a month straight in summer. Things like, so things like that. Because 4 hours is not horrible, but it's very challenging. But when I have cases about relocation where a parent is moving out of state, usually far away, if that's going to be either ordered by the court or consented to, this is what we try to do. Because when you add the number of days, in many cases, you're actually having more if you get more of the school vacations, more of the holidays, a larger summertime. And while you may not have the frequency of contact like every weekend or every Wednesday, you're getting much more meaningful contact because you're not spending 8 hours in the car and you're spending many days together as opposed to like 1 or 2. So did that answer your question? And if it didn't, let me know. And if it raised more questions, let me know. And while he's thinking about that, I'm going to see if there's any other questions. Okay, so I am currently picking up my child and bringing her to my home each visit, so it ends up 16 hours of driving for each visit. Right, 2 round trips. It's fair to request that she share some of the driving. It's not a question of fair. It's just a question of whether a court would do it. I think it's reasonable to somehow split this difference, even if it's 1 hour and 3 that you're doing, or you pick up and she drops off. But that question will often turn greatly by who created the distance. So, and I'm guessing that you may have, because your custody is in New Jersey and you're not. So you probably put the distance. But if you were required to do so, or if this was a plan when you were with mom in a relationship and then things changed and now you're not with her, or just out of basic fairness, that there should be some kind of distribution of the drive, you can certainly ask for it. You may not want a long distance relationship. Okay, so there you go. That may actually help you, because she knew when she was getting into a relationship and electing to have a child, because nobody accepts that it was an accident excuse anymore. She knew she was having a child with a person who lived 4 hours away. It's compelling to say that she should share in this driving. And then you throw in it's 2 hours that she gets to sit in the car uninterrupted time with your son. That's good time for them. It's fair for you. It breaks up the trip for him, which is better for him. And all around is fair. So I would say you should be able to ask for it. I'd recommend you use these points, especially that she knew there was going to be this distance, And this goes back to, again, the old mentality that, women get custody and dads have to do the work. They have to pay the child support. They have to do the driving. It's not fair. And it's not necessarily the way that it is anymore with every judge. So certainly give it a try. All right, like I said, anybody else has questions, I'm here as long as you need me to be. I appreciate everybody coming out and spending the time. I hope everybody's staying safe in this crazy sort of COVID time. It's still going around. I think a lot of us feel like it's passing, but yet it's not. I know, actually, I spoke with a client today who, unfortunately, he and several members of his immediate family got it, but luckily it was a softer case and they got through it. But it's still there, so everybody be careful. Not seeing any more questions, so I'm going to be signing off. You should have my email, which is brad@Micklin. I got another question, so hold on. Something we should have been resolved in a few weeks has taken a year. My court date has been delayed 5 times. Is this normal? Well, when you say normal, nothing is normal right now because of COVID. And every county is different and every judge is different. So the delays from the last year, because you're saying it's taken a year, is not unusual for COVID. It's not necessarily unusual even pre-COVID that your case would be adjourned a few times or something can take a year. So the courts, here's the thing about litigation in general. Everybody thinks that family court is just this all horrible, throw down, drop dead battles. And they're not. Those are the actual aberrations. Those are the unique stories that you hear about. But because you hear them, you think that's the norm. And I say that because if you have a difficult case, you have a high conflict case, you have a challenging adversary, mother or opponent, whoever it may be, courts aren't always that equipped to deal with it because it's not very common, or it's not as common. Most cases are reasonable and easygoing, and the majority of people settle them. So when you have a unique issue or a difficult party, it can take a year to resolve something because the courts are over. Just lost my train of thought. They have too many cases. They are backlogged now because of COVID. But even, like I said, even before COVID, a custody case could take a year. Between the practices between the time frames that court schedule and their ability to counter cases given how many they have. yeah, it's not unusual for a custody matter to take a year. Judge has been delayed court dates. Judge has been delayed court dates repeatedly because of emergencies that keep coming up. Right. So here's the good and bad about what's happening with COVID is before, and it depends how you feel about these things, but before, every case was listed at 8:30. So everybody took off work, got in their car, drove to the court, parked, paid for parking, went up and sat in the hallway with everybody else. And you would have 10, 20, 30 cases sometimes sitting out in the hallway. Now, courts can only hear one at a time. So most of us would sit sometimes for hours and hours, and often just on routine hearings. So that wasn't very productive. But the good that sometimes came from that is you could talk in the hallway, you could try to resolve it, and because you were being financially pressured so much between missing work and paying legal fees, it often coerced you into settling it or being more reasonable or compromised, whatever it may be. So now we don't have that, and that was a lot of waste. I was never a big fan of sitting in the hallway for 3 hours waiting for a hearing that was routine. That thing is just wasteful to the client. So now that's gone. I get told I'm scheduled for 10 o'clock, and at 10 o'clock I turn on my computer and we're there. And what used to take 3, 4, 5 hours may take like 15 minutes. So it's great in that sense. But the problem now becomes, one, judges weren't accustomed to handling cases on a certain time, saying at 10 o'clock you got to hear this case. But you can't predict how long a case is going to take, how much talking a person's going to do. They can't predict that an emergent application is going to come in and bump that calendar, or that a judge is going to be sick, or the Zoom camera doesn't connect. So there's all these new problems that we're still learning to deal with. At the same time, we're learning how to do hearings this way. So it's kind of like you step back to step forward. And that's what's happening right now. We're adjusting to the new way of doing business. And, I think when COVID's past us, that some of these changes will remain. I still think we're going to have some hearings by virtual appearance, like the routine ones, hopefully. And I think we'll return to having some in court. So you're going to have like a blend of these issues. But with that, it's going to come new issues. There's always going to be issues. There's always going to be delay. There's always going to be a lot of stress and finance involved. It's just part and parcel to the system. Any other questions, comments, anything I can do while I am here? All right, seeing none, as I was starting to say before, on the bottom is my website. You can click on that and go to my video consultation room, and you'll see several videos on various topics. And it's broken down, divorce videos, family law videos. And if you don't see things you need there, go to my YouTube page, which is just Brad Micklin, Micklin. I have videos, try every week, more like every other week. I try to put videos up because people don't even know what to ask often when they come to meet with me. So I put up some resources so you can learn about the law for free and get a better sense of what you need. I have one going up hopefully early next week about what happens after you've been to mediation. But there's countless videos on all different topics that would hopefully help you. And with that, I'm going to sign off. Like I was starting to say before, I hope everybody's staying safe. I wish you the best, and let me know if we can help you. Have a good night.